Dear friends, I am Tanu Singh from Origiin IP Solutions LLP, a Bangalore-based leading intellectual property rights firm. As you know, in today's dynamic and competitive business environment, intellectual property or IP is a key element needed to maintain a competitive edge in the market. IP as a business asset is an integral part of the business process. Effective acquisition, management, and protection of IP can mean the difference between success and failure in businesses today. For business growth of any enterprise, it is important to protect the innovation and ensure that the IP rights of any third party are not infringed. Purpose of this presentation is to give you an overview on intellectual property rights, various types of IP, their importance in business, and roadmap to IP process. The term intellectual property, as the name suggests, means creation of mind or the intellect. In our day-to-day life, we come across various forms of IP, such as movies, songs, electronic devices, drugs, etc. One acquires legal right over IP once such IP is registered. This means that in order to protect IP, registration under appropriate legal regime is essential. Legally speaking, the term property essentially means a bundle of rights flowing from the concept of ownership and possession. With this concept in the mind, intellectual property right or IPR can be defined as the right held by a person over the creation of his mind for a particular period of time in a given jurisdiction. Intellectual property acquires legal rights in the form of patent, copyright, trademark, industrial design, etc. It gives the creator an exclusive right over the use of his or her creation for a certain period of time. US Constitution has a specific reference to IP, and US Constitution authorizes Congress to protect patents under Article 1, Section 8, Clause 8, which reads as, Congress shall have the power to promote the progress of science and useful arts by securing for limited times to inventors the exclusive right to their discoveries. It is interesting to note that Indian Constitution has no mention of IP but just the word property, and hence all attributes of word property have been also assigned to IP, such as Article 19, which speaks about freedom to acquire, hold and dispose of property. Article 31, which speaks about protection from deprivation of property. And Article 32, which speaks about property could be possessed or acquired for public purpose only by law and only on payment of compensation. Intellectual property right is a collective term, and depending upon the type, IP can be protected under different legal regimes. Patent is one of the most talked about form of IP, wherein the invention that are novel, industrially useful, and are non-obvious to a person skilled in the art get protection. Patent is a set of exclusive rights granted by government to an inventor or their assignee for a limited period of time in exchange for a public disclosure of an invention. Patent rights are territorial, that is, a patent granted in India is valid only in India. To have protection in other countries, inventor is required to file patent application separately in other countries. Life of a patent is 20 years from the date of filing. Now, copyright. Copyright is a right given by the law to creators of literary, dramatic, musical and artistic works and also producers of cinematographic films. Copyright gives protection to the expression of an idea and not to the idea itself. For example, a software code which is an expression of an idea and is protected as a literary work under copyright law. whereas the idea behind the software may be protected as a patent, provided it satisfies the criteria of patentability. The total term of protection for literary work is author's life plus 60 years. Now comes trademark. Trademark is a distinctive sign which identifies certain goods or services as those produced or provided by a specific person or enterprise. Trademarks may be one or combination of words, letters, or numerals. It may also consist of drawings, symbols, three-dimensional signs such as shape and packaging of goods, colors used as distinguishing feature. Industrial design. Industrial design means the feature of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional or in both forms. A design is judged solely by the eye, but it does not include any mode or principle of construction or anything which in substance a mere mechanical device. Semiconductor Integrated Circuits Layout Design Act 2000 provides protection to semiconductor IC layout designs. Geographical indication. A geographical indication is a sign used on goods that have a specific geographical origin and possess qualities or a reputation that are due to that place of origin. Most commonly, a geographical indication consists of the name of the place of origin of goods. For example, Darjeeling tea, Kashmir saffron, Chanderi sari, Mysore silk, Bidri ware, Coimbatore wet grinder, Channapatna toys and dolls, etc. Now comes trade secret. A trade secret refers to data or information relating to a business and is generally not known to the public and which the owner reasonably attempts to keep secret and confidential. Coca-Cola is the most common example of a trade secret which has been kept secret since long. Traditional knowledge is knowledge, know-how, skills, and practices that are developed, sustained, and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. The Protection of Plant Variety and Farmers' Rights Act 2001 provides for the establishment of an effective system for protection of plant varieties, the rights of farmers and plant breeders, and to encourage the development of new varieties of plants. It is important to understand that while protection of own IP is important, but at the same time it is equally important to take precaution not to infringe any third party's IP rights. Hence, one should protect own IP and respect others' IP as well. Here are few examples to show that how third parties may misuse one's IP if not protected properly. For example, in Texas, Rice Tech patented modified basmati rice, which is traditionally grown in India as well as Pakistan. There are 200 medicinal plants from a country on which multinationals are trying to take patents. The fundamental question asked by most of the people in organizations is, why is IP important for us? Especially for service-based organizations where IP developed during the process of execution of the projects that belongs to the client. It is actually a tough question to answer. That's why is IP important, especially when we are not going to own it. However, meaning of IP is much beyond just protection or registration of IP. The first reason why IP is important for an organization is that it develops culture of innovation. Inviting new ideas from team members, documenting them, appreciating and recognizing gesture of the team members helps immensely in creating culture of innovation and boost spirits of the team. It helps in upgrading core technologies and gives focus on direction to R&D. For example, if an organization is into manufacturing of medical devices, assessment of existing patents that relate to medical devices will be extremely useful to add value to existing products, and further analysis of the same may be helpful to assess chance of IP infringement. In fact, during patent search, one might come across some interesting patents not filed in the countries of interest, which means that they can be used without any fear of infringement. However, legal advice is a must before deciding to implement such patents. Awareness of IP helps to minimize patent infringement risk. Before a product launch, it is critical to ensure that patent rights of any third parties are not infringed. This kind of search is called as clearance search or freedom to operate search. An organization can build reputation in the market by having good patents in its name. As soon as a patent application is filed, the products or process related to such patent application may be labeled as patent pending or patent applied for. This can be used very well as a marketing tool. Patents are intangible assets, and there have been various cases where value of such intangible asset is much more than tangible assets. IP as such can really add lot of value to the organization and can generate revenue by various means. Now the question is, where to start from? Well, to start with, you can always take small steps and implement the process to ensure that there is awareness of IP within organization, which in fact is the first step. Having good IP policy is a must to address IP related issues. However, enforceable agreements with employees, freelancers or contractors is essential to protect confidential information or trade secrets of the organization. State-of-the-art is valuable information that is already existing in the form of patents or non-patent literature such as articles, magazines, etc. State-of-the-art may be taken as a vital tool to fine-tune existing technologies. Having knowledge of what is already known or done by others is vital for you to develop technologies further. Due diligence and infringement analysis in any case is essential to ensure that one doesn't infringe IP rights of any third parties. Confidential information and trade secret is a valuable asset, and since it can't be registered, it has to be taken care of by maintaining confidentiality of the same. However, often organizations fail to identify and hence protect it, and unfortunately, once such information is leaked, it is lost forever and there is no way to recover it back. Anand Electronic and Futuristic Concepts Media Limited were using digital transmission system technology to manufacture VCDs. In India, Philips had a patent protection on this technology. In the year 2003, Delhi High Court ordered the two Indian companies to stop manufacturing the VCDs that infringed Philips' digital transmission system. So, what's the lesson behind this? Using technology protected by another company can drive you even out of business. Recently, Apple was ordered to pay $368.2 million in damage to Vernex for infringing 4 US patents used in its FaceTime video calling service. The company was sued by a small company, VernetX, which has registered a number of video-related patents between 2002 and 2011. This is in fact an excellent case to understand strength of protection and enforcement of patent as a tool to obtain competitive edge in market, as well as use it for revenue generation. We at Origiin IP Solutions provide intellectual property solutions specifically in the area of patent registration in India and abroad, registration of copyright as well as industrial design. We also offer services in the area of patent searches, drafting of contract and license agreements, and training on intellectual property law. We provide end-to-end solutions and services to the clients by assisting them with identification, analysis, protection, management, and exploitation of IP in an effective manner. Our mission is to enable our clients to realize long-term value and benefits from IP by identifying, securing, exploiting, and managing it in best possible manner. Contribute to the society and nation by making the industries and academia aware about the legal provisions and concepts of IPR in a simplified manner, thereby enabling them to secure, exploit, and manage it effectively. Purpose of this presentation is to aware users on the basics of IPR. For specific issues related to IPR, it is strictly recommended to take professional advice. Thanks for listening to the presentation. For any queries related to intellectual property rights, please feel free to contact us over phone or mail us at info@origin.com. Do visit our website at www.origin.com. Thank you.